Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Jordan's. We reviewed it before. It's a first-class book and it deals and is effectively the substantive work in terms of the Court of Protection practice. It's called Court of Protection Practice 2016. The general editor and main contributor is Gordon R. Jackson, OBE, and as OBE. Gordon R. Ashton. He's well known to many of you. He certainly has a huge amount of knowledge of this subject. It's a very important book and one that I'm sure anybody involved in Court of Protection matters will have in their library. Now, Elizabeth and I have given the title of our review the following: The Definitive Work in a Difficult Area of Law, now in a new edition. Now, this is an area of law that's got a lot of publicity recently, not all of it good. However, it's a very difficult area, and this book I think does actually make a great deal of difference to what we're doing. Here is the front cover. That's the side. You can see the people involved. There's nothing on the back. Now what you've got a list of the people involved. What you have got in the book is the shaded areas, so you'll be able to find things quite easily. It's a big book. It's got a CD at the back, and it's also got on the inside back cover useful information. Likewise, you've got a calendar on the front, which again is quite useful. Let me just start at the back though first to give you an idea of what's in this. You've got fixed costs, again also extremely useful information at your fingertips. It runs to 2,600 pages, and you can see from this, that's the index. The index is done by page numbering, and the index is very similar. It's a very standard house style for the actual information, and you can see from the beginning of the index there how it's actually structured. What you've then got before that is part 12, which deals with the directories concerning the information. But let me go to the front, because as I say, all the shaded areas run through the different parts. What you've got right at the beginning is the front page there. The pages are very thin, so do be a bit careful. They do crease a little bit as well. And then you've got a very large number of people involved in this publication. You can see the names of the people listed. It starts at the top with Gordon Ashton, and then it's got a whole range of people underneath, some of whom you'll know: District Judge Mark Marin, Claire Van Overdyke, and Alex Ruck Keane, to mention just a few. Then you've got a foreword by James Mumby as President of the Court of Protection, and Mumby, of course, I will refer to in a minute. Then you've got a little bit further information there. Then you've got Mark Potter from December 2008 with the foreword to the first edition. There's a preface to the first edition, again written by Ashton. And then we get to where we are now, which you should read, because this gives a very short statement, effectively, on what has been happening. I say short because it does actually run into a few pages, but it is actually very important. It's been written by Mr. Justice Charles, and I think it's a very important point to make. Then you've got the main introduction, European Convention on Human Rights. Of course, we're going to be looking at that again, I'm sure, very shortly. It also talks about access to justice. That means legal aid, of course, and the secret court argument, all of which have been featuring, as I say, in the press. And that's, as I say, that is a comment written by Gordon as the editor-in-chief. Then you have the contents section itself, calendars and so forth, all the leaders, table of statutes, then table of cases. You've also got statutory instruments as well there. Then after that you get to the contents itself, which is extremely helpful. You can see how that is structured. You do actually have quite a useful thing, which I should have mentioned, which is the list of abbreviations, because they do come into this as quite important. And the part one is the narrative, and then it runs all the way through, and you can see immediately how the subject is covered. Now what you've got after that for part one we get into the detail of the book itself. Now you can see it's paragraph numbering and it's got footnotes, so you should be able to find what you're looking for pretty quickly, both through the index at the back and the contents at the front. Court of Practice and Procedure, this is chapter 8, still in part 1. You can see it goes through all the particular questions you would probably have to ask, and you've also got, of course, all the practice directions and all the other information. You should have everything that you need, because this is the ultimate work for this particular court. Now, what do we say about the book? Well, as I said, we've reviewed this before. It is the premier book, without a doubt. It's something which I'm very grateful Jordan's, now owned by LexisNexis, are still publishing, because it's absolutely fundamental to work in this particular jurisdiction. This is what we say: there's scarcely any other area of law that is as complicated and sensitive as that pertaining to matters that must be adjudicated in the Court of Protection. With its beneficial fusion of scholarship, clarity and compassion, this book from Jordan Publishing has become the definitive guide to every conceivable aspect of Court of Protection practice and procedure. Now, writing in the foreword, Sir James Mumby, President of the Court of Protection, has pronounced it as essential for all those who work in or appear before the court, notably every judge and practitioner, and you'll see the book in the court when you go in. Of course, no institution is perfect, and as Mumby has pointed out, a number of flaws that need to be addressed, while at the same time referring, for example, to the now streamlined process for dealing with deprivation of liberty, Doll's cases, which is now up and running, facilitated by the welcome recruitment from the tribunal judiciary of additional judicial assistance for such cases, has of course been taking place. And Sir James refers in addition to certain ongoing developments aimed, for example, at moving Court of Protection techniques in much the same direction as those that have proved successful in the family court. And obviously he's got an interest in that as well, but you can see that there is an attempt to try to standardise things. But obviously we still do have some areas where there is a lot of sensitivity and there's a lot of difficulty, hence the tag of secret courts, which is an unfortunate description in some respects as to the way in which they conduct their business. Certainly, however, the credibility of the Court of Protection is identified by the General Editor, Gordon Ashton's introduction, as one of several significant challenges facing our mental capacity jurisdiction, which, as he refers to as a valuable jurisdiction. He's absolutely right. It's an important area. It's an area that Parliament, if you reflect on it, has not really been able to get full agreement over the last couple of decades. But we do certainly have a comprehensive system, and we have this book, which is the comprehensive practice book for the Court of Protection. And as I said, we would really be lost without it. So thank you to Jordan's. What is particularly interesting, we feel, about this book is that it reflects the radical attitudinal changes for the better, in our view, toward those with mental and physical impairments that have emerged during the past quarter century. We've come a long way quite quickly, in other words. As the editors stress, that, quote, there is now a new social and legal climate that emphasises personal autonomy, favours community care, and disapproves of discrimination in any form. And that is very much the way things have been and will continue to be in this particular jurisdiction. So bearing all this in mind, it's no surprise that this highly regarded legal text is conspicuously client-centric. We must never overlook the fact that it is for the benefit of that person, not the lawyers, says Ashton, that this valuable jurisdiction exists. I think it's also important to note the quote from Lord Woolf to the effect that the litigant in person is regarded as a problem for judges and for the court system, rather than a person for whom the system of civil justice exists. Now, I've reviewed a lot of books. Elizabeth and I have certainly covered a large number of books, and we're well aware that there is a need, probably a fundamental need, to review the way in which litigants in person are viewed, because we are clogged up with them. There's no doubt about it in the court system because of the lack of legal aid, and a lot of people are doing the cases themselves. We also have a more intelligent population, putting it bluntly. They understand their rights more, to a certain extent. Perhaps it'd be useful if they understood them a bit more in the future, but they certainly do understand. So we are entering a different era and a different approach, and I think Lord Wolf's point about LIPS, litigants in person, being regarded as a problem for judges, it's something that really will have to be resolved in the longer term, because I don't see a return to the old system of legal aid as we had it. Let me continue by saying the aim of the judge, adds the commentary, and this is looking specifically at LIPS, litigants in person, is it should be to ensure that parties leave with the sense that they've been listened to and have had a fair hearing, whatever the outcome. Now, I wish I could say that that was the case. Unfortunately, I have to report back to you that normally a lot of my clients will accept what has happened. But I think there's a growing trend of people are feeling they're not actually getting the sort of justice they want. And sometimes with things like summary judgment and the refusal to have proper trials so that you can cross-examine witnesses, has caused a really serious problem of credibility in some courts. Because the bottom line on this must be that people should be able, if they have a grievance, to have it properly aired so that both sides are heard, as a fundamental principle of natural justice. That, unfortunately, seems to be going in some courts, and I hope that that nasty little policy area of granting too many summary judgments is not continuing. Obviously, with this particular area of practice, it's slightly different. The book's got almost 3,000 pages, and it's fortunate that it's not only easy to use, it's also a veritable mine of reference material with resources for Court of Protection practitioners. It's the ultimate work, and I think a very important one. The index at the back and the 17 pages minutely detailed table of contents at the front, I think, make it also very easy to look things up quickly, depending on what you're after. As I've said, I think they're trying to get the best possible balance they can, and I know Ashton and his team have achieved that. Extensively footnoted out throughout, of course, with numbered paragraphs. The book is divided into 12 parts, and as I say, you've got the shading. I'll show you that again in a minute. Throughout the book, so you should be able to find things pretty quickly. I know that we all use post-it notes and everything else, but you should be able to find things quickly. The 12th part being an almost 30-page list of directories. That's immediately before the index, from everything from carers and care homes to wills and probate. And on the back inside cover, which goes where the accompanying CD is, there's the handy list of fixed costs, which I've said are very helpful. Notwithstanding, you can always refer to the internet, but the fixed costs are, I think, very, very useful to have. Let me conclude by saying finally that, containing much new material, this 2016 edition is, I think, a very distinguished volume, and it's a must-have purchase clearly for all practitioners involved in what is a very difficult area of law. Now, the editors have endeavoured to state the law as at the 1st of December 2015 with some later additions, and I'm recording this in the late summer of 2016. So here's the book again. It's a heavy book, a nice hardback. There's the front. You can see the list of contributors. I haven't gone through all of them by name. Just to remind you again, the parts are shown in the shaded area, so you should find things. The index, you've got the CD and the inside back cover with costs and so forth. Just to remind you, the index is very detailed, and of course at the front, again, the contents section is also of great assistance, so that you should be able to find things pretty quickly. Obviously, looking at the basic, this is deprivation of liberty safeguards, for instance. Again, a very important area. You can see, just taking this, what you've got. You've got the paragraph numbering, and then you've got the very detailed footnoting. So you should theoretically be able to find everything that you want. I'd like to thank Gordon and his team very much indeed for this, and to Jordan's for undertaking to continue publishing this work. We can't do our jobs without having this information. When I think back a few decades now to what we had, I think we are very well served in this modern era by the publications, and it's down to the publishers and to all the people contributing that make our lives so much easier. So thank you very much to everyone. Bye bye.